A lot. Thank you, Mr. Chairman. We have worked a lot together on this to find the common ground areas. Regulatory reform shouldn't be a partisan issue. It should be a conversation about how we actually deal with actual business and operations. We have 3 bills that we have worked very hard together on. Let me just kind of walk through the basics of those, and then we'll get quickly to our witnesses on it. 1817 deals with what we call the Smarter Regs Act. That act just starts laying out a plan for retrospective review. We believe there should be an assumption that when every major regulation is passed, there is an assumption there will be a retrospective review, and that will be a time certain. So we give a 10 years or less that the agency, when they promulgate the rule, they say this will be reviewed at this date. So everyone knows we're going to do a real cost benefit analysis after the fact to really we know what it was estimated, then we'll get 7 or 8, 10 years, whatever it may be, whatever is set, to get the real analysis of it, and then at that time, a new date is set for the next time as well, and you just keep that going on a major regulation. Again, what we believe is there should be this continual improvement, and not to have you put a regulation in place and assume 30 years from now nothing has changed. Well, 30 years from now, things will have changed in the world, and we need to make sure there's a continual look back on that. Another one I want to be able to bring up to you of the 3 that's here, what is 1820, the Early Participation and Regulations Act. Again, we have this crazy belief that the government still is of the people, by the people, and for the people. And if it's a nation and a government of the people, by the people, for the people, that actually means people should be involved in the rulemaking process. That if an agency promulgates a rule and then it seems like everyone's trying to fight against the text of it, maybe we should back up and do an advance notice of proposed rulemaking, so when we get into the major issues, the agency would put out the concept and then would have an opportunity for all the American people to engage early to say this is something handled by the states, or yes, this is a major issue that we need to do it, but when you do the rule, make sure it includes these areas. It will improve the input early on, and will also allow people to be engaged in it, to have more common sense rules come out. So when they're actually promulgated and you get to that stage, the majority of people have already looked at it and had good input, and now you really are tweaking it rather than fighting against it. And the third one is 1818. This one deals with just a very basic thing that should not be a controversial thing, we believe. For the past 20 plus years, regulations have been promulgated based on 2 executive orders, 12866 and 13563. That the president has over and over again, both Democrat and Republican presidents, said we need some basic standards of when we produce regulations. We should consider the science. We should look at cost-benefit analysis. We should consider the best available other methods and alternatives that are out there. You should get quality public participation, not only from cities, state, tribal governments, but also from affected parties. You should look at scientific objectivity. These are commonly agreed on things that function under executive orders that have never been codified. So our belief is, we know where we have been in the past. We don't know where we're going on this. We would like to have these commonly agreed upon principles be codified into statute. And so we know from here on out, when regulations are actually created, these basic requirements are put into place. So again, we feel like these are common ground issues that Republicans and Democrats alike can wrap around and start to make some significant regulatory reforms. I look forward to the conversation today that we have had at multiple times, being able to look through this and also broadening this out, and then to head towards a markup and try to actually put this into statute in the days ahead. So that I yield back.
Thanks, Senator Lankford.
Thank you all for being here. Let me ask, and I want to be able to follow up in the same conversation we had about the BRAC-like commission. The concern that I have is I want to be able to talk a little bit about today is the time period. Again, you have 9 individuals taking on a lot of regs from across multiple agencies. Their time to be able to get up to speed on it and then to be able to make a good decision, make the proposal and get out, is the length of time that's allotted. Do you think that is enough time for them to be able to study it, get public input, make a good recommendation, and then send it over to Congress? Or what kind of time period will that commission need to be able to get good input, do their own research, get conversation with agencies, and get it done?
I'm not sure what is in the bill, but I think it should probably be 2 years or so. I think
it's 2 years. I'm just trying to figure out if it was a 2-year time period for them to be able to actually work through the process.
Yeah, so you need at least that much time if you are, I believe so strongly in public comment, because I think that there's information that none of us have individually that you could get from that open comment. So I think there needs to be adequate time for that.
Okay, Mr. Shapiro.
Thank you, Senator. I think that's a realistic concern, and I'm not even sure 2 years does it. The fact of the matter is many of these regulatory statutes are just really complex.
Sure.
There are defensible reasons for that and sometimes not defensible reasons. And so to understand whether or not a particular regulation is doing its job and is appropriate, you have to also understand the statutory scheme. And it's all I can do to teach one subject in law school. I certainly can't teach 4 or 5 with any kind of mastery of environmental law and food protection law and consumer protection law, and of course add that up across our government.
Let me follow up a little bit on this conversation about judicial review as well. Studley, you made a comment that you feel like judicial review makes for better regulations because there's accountability built in. I would tell you, when I talk to those that are regulated, they struggle with a place to go when they have a complaint. When they feel like something is truly not working, Mr. Spiro, you talk about this backdoor opportunity to be able to go to agency. They feel like when they take that back door, someone says, no, we wrote what we wrote, and they have nowhere else to go. If there's not a regulator that's actually engaging with them to say, this really is a problem, where do they go? So the mechanics of that, do you have concerns or comments about this judicial review and then opening that up for you Ms. Dudley?
I think judicial review, there will be some cases that we all might look at and say, what were they thinking? Because judges don't necessarily have the skills to evaluate a regulatory analysis. But I do think the analyses will be better done if agencies know they're going to be subject to review. That's just the way we all work. If they know that there's going to be oversight, it will be done. It will be a better analysis.
Okay. Do you think it gets out of control in a hurry? That there ends up being so many cases that are filed that this quickly gets out of hand?
I don't know. I mean, we don't see that with the executive branch agencies. Are you asking more? Well, I guess yes. We see a lot of litigation, right. And I think what I think it would do is it would allow people to be litigating on the matters that really are the trade-offs that they're really thinking about, rather than having to litigate on a few words that maybe really weren't what everybody's talking about. Right. I'm not sure I made that very clear.
That's okay. Well, the challenge is we want to get it right. I think judicial review is important. I think it's the accountability that you had mentioned before that does create that accountability out there, and it gives someone to be able to protest to that literally doesn't work in the cubicle next to the person who made the previous decision. So it gives you some opportunity to get an outside opinion on it, but I think it should be used sparingly. And so trying to be able to build into the language something that actually works so that you have that opportunity, but it's not abused.
Well, I'm sitting next to an administrative law professor who can correct me if I'm wrong, but there already is the Chevron deference doctrine that would require, would lead the judges to defer to the agencies unless there's something that's egregious.
Which I would love to be able to discuss at length, because Chevron deference, I think, is one of those areas that has grown up and is now out of control in many ways. When there's the challenge to find, as we have mentioned already previously, statutes that are 40 years old that we're now interpreting in a way that was never considered by the original statute. There is no new statute to be able to bring it, and they have deference to be able to expand it. Now you really do have a regulator that looks like they're writing law, but they're just expressing deference for an unconsidered item that's 45 years ago. So the challenge is, how do we actually wrap back around that and say we don't need to have Chevron deference that expands this far for something this old? So, Mr. Spiro, you look like your smile on your face might have an interest in that.
This is why my students don't like administrative law, Senator. We have this quandary, right? In Chevron, it's not unlimited deference, and various judges disagree about various approaches. Yeah. And at some point, the courts will say that's just outside the bounds of what Congress intended. But from the agency's point of view, there's a pressing national problem, climate change. It's their responsibility to try to deal with it. And so they propose, to the extent they can, to address that through existing statutory procedure. I actually think the problem for agencies, though, is not so much Chevron, but a very detailed and careful review of the factual and legal basis, particularly the factual basis for a rule called hard look review. So we have courts of appeals out there that have very demanding analytical requirements in order to sign on to a rule and affirm it. And the difficulty is that agencies have trouble with coming up with precise evidence on every point. The world's uncertain. Scientific evidence is uncertain. Cost-benefit analysis in particular is uncertain. And so when we say, for example, that an agency didn't quantify a particular benefit, that may be just sloppiness, but it's also very difficult to know how to quantify some of these benefits. So we have to find a way of both using cost-benefit analysis, which can give us useful insights, but not ignoring obvious benefits that we just can't quite find a way to quantify very accurately or at all.
Correct. It does seem that we can quantify the cost, but the benefits seem to get out of balance at times, and that's one of the other big challenges, is trying to get the cost benefit to align on there. If we have 5 years of cost and 20 years or 25 years of benefits, suddenly we're out of balance here and we're skewing things one way or the other. Or when you take a long look on it, knowing that most of the costs will be early and most of the benefits may be far delayed, again, we're skewing the process on it. So I would like to continue this. Well, obviously, I'm out of time, but I would like to continue this conversation in the days ahead on Chevron deference. I do think this is a big issue, that we have so few laws that are being passed right now and such large effects on things where an agency feels like they have the responsibility, as you mentioned, to address it, but they don't necessarily have the legal authority to address it. Our system demands a new law is passed rather than the agency saying, it's our job, we'll just create this. So with that, I yield back.
Senator